To make your immigration process easy, we upload videos regularly in this channel. In this video, we are going to let you know an update of U.S. immigration developments for the month of July 2022 and the potential impact on U.S. employers and foreign nationals.
Visit our Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
Let's get into the video. Update number 1. USCIS extends COVID-19 related flexibilities through October 23, 2022. U.S. Citizenship and Immigration Services is extending certain COVID-19 related flexibilities through October 23, 2022 to assist applicants, petitioners, and requesters. Under these flexibilities, USCIS considers a response received within 60 calendar days after the due date set forth in the following request or notices before taking any action if the request or notice was issued between March 1, 2020 and October 23, 2022, inclusive. Requests for evidence, continuations to request evidence, and FORTINA, notices of intent to deny, notices of intent to revoke, notices of intent to rescind, notices of intent to terminate regional centers, notices of intent to withdraw temporary protected status, and motions to reopen and end 400 pursuant to 8 CFR 335.5. Receipt of derogatory information after grant. In addition, USCIS will consider a Form I-290B, Notice of Appeal or Motion, or a Form N-336, request for a hearing on a decision in naturalization proceedings under Section 336 of the INAF. The form was filed up to 90 calendar days from the issuance of a decision that USCIS made, and USCIS made the decision between November 1, 2021 and October 23, 2022, inclusive. In an effort to take the lessons learned from USCIS's pandemic posture, the agency has been evaluating which flexibilities can and should be extended permanently. As a result of this evaluation, the reproduced signature flexibility announced in March 2020 will become permanent policy on July 25, 2022. Update number 2. Biden administration proposes national ID cards for undocumented immigrants. The Biden administration has proposed a new national identification card system for undocumented immigrants. The Secure Docket Card program would give migrants who cross the U.S.-Mexico border and other immigrants without legal status temporary ID cards as they navigate their immigration cases or removal court proceedings. The details of the pilot program have not been finalized, but the ID cards are likely to include a photo, biographical information, and a QR code that would allow the holder to access their court information and immigration documents online. The program is designed to modernize the immigration system, while also lessening the bureaucratic paper burden of the process on immigrants. The Biden administration has allocated $10 million for the pilot program in the upcoming Department of Homeland Security Appropriations Bill. Democrats are aiming for congressional approval before the end of September 2023 in order to make the proposed plan a reality. Update number 3. Bipartisan bill would lift per-country visa caps. Senators from North Dakota and Colorado introduced a bill aimed at allowing more people to enter the U.S. through employment-based visas, saying that U.S. employers should be able to hire workers based on merit rather than birthplace. Senators Kevin Cramer and John Hickenlooper said in a joint statement that the Equal Access to Green Cards for Legal Employment Act of 2022, or the EAGLE Act, would effectively create a skills-based immigration system that would ease workforce challenges and relieve immigration backlogs by phasing out the country's 7% cap on employment-based visas over a 9-year period. Currently, foreign countries are each allowed to receive only up to 7% of the 140,000 total employment-based visas the U.S. gives per year, a number set out in the Immigration and Nationality Act. The senators said that while the visas seemingly start off as being merit-based, given that employing sponsors are required to show a need for foreign workers, visas are ultimately distributed based on the immigrant's place of birth. Nearly 67,000 employment-based immigrant visas went unused in the last fiscal year. Despite countries having qualified applicants, the senator said. Furthermore, roughly 95% of immigrants who are in the U.S. on temporary employment-based visas are still waiting for permanent work visas, they said. The senators said many of these immigrants on temporary work visas wait years and even decades to get their permanent visas due to entry caps on their home countries. The EAGLE Act also allows individuals who have been stuck in the immigrant visa backlog for 2 years to file for a green card application, but they would still have to wait until their visa becomes available, the senators said. Update number 4. Congress introduces bill to regularize long-time undocumented immigrants. A group of Democrats in the U.S. House of Representatives recently introduced a bill that would allow long-term undocumented immigrants to apply for green cards after 7 years in the country. The bill, named the Renewing Immigration Provisions of the Immigration Act of 1929, would create a rolling registry date, which is a mechanism in immigration law that allows people who have been living in the country for a certain number of years and who are good moral character to apply for permanent residency. Under current law, an immigrant must have arrived in the U.S. before January 1, 1972 and lived here continuously since that time. Because the date has not been updated since 1986 and is so far in the past, few of the estimated 10 million undocumented immigrants in the U.S. can benefit from the current date. By implementing a rolling date rather than a fixed date, the bill would not need to be updated by Congress again in the future to keep the provision active. It is estimated about 8 million immigrants could benefit if the bill is passed. Update number 5. USCIS to implement second phase of EB1 and EB2 premium processing. On July 15, 2022, U.S. Citizenship and Immigration Services announced that it is implementing the second phase of the premium processing expansion for certain petitioners who have a pending Form I-140 immigrant petition for alien workers under the EB1 and EB2 classifications. Similar to the first phase of the expansion, this phase only applies to certain previously filed Form I-140 petitions under an E-13 multinational executive and manager classification or E-21 classification as a member of professions with advanced degrees or exceptional ability seeking a national interest waiver. Petitioners who wish to request a premium processing upgrade must file Form I-907, Request for Premium Processing Service. Beginning August 1, 2022, USCIS will accept Form I-907 requests for E-13 multinational executive and manager petitions received on or before July 1, 2021, and E-21 and IW petitions received on or before August 1, 2021. USCIS will reject premium processing requests for these Form I-140 classifications if the receipt date after the dates listed above. USCIS has 45 days to take an adjudicative action on cases that request premium processing for these newly included Form I-140 classifications. The agency said it will not accept new Forms I-140 with a premium processing request now. On May 24, 2022, USCIS published a new version of Form I-907, dated May 31, 2022. As of July 1, the agency is no longer accepting the older 9/30/20 edition of Form I-907. Update number 6. Biden administration works to naturalize non-citizen veterans. The Biden administration is urging military veterans who are not U.S. citizens to naturalize and become citizens, with the Department of Veterans Affairs beginning this week to contact the nearly 124,000 military veterans who are not U.S. citizens with information about how to become citizens. The Department of Defense provided the names of veterans who were not U.S. citizens at the time they left the military between 2001 through April 2022 to the VA, said Saif Khan, who is an advisor to the VA General Counsel. The VA plans to make a series of attempts to reach veterans by phone and email over the course of the year after they separate from the military. Khan, who is a veteran and naturalized U.S. citizen himself, told NBC News that he sees the efforts to promote naturalization to veterans as doing the preventative work of keeping veterans from being deported. a separate effort is being launched to repatriate veterans who have already been removed from the country. The naturalization outreach to non-citizen veterans is part of the Biden administration's whole of government approach to promoting naturalization, the process of becoming a U.S. citizen. Update number 7. USCIS reminds employers that they only accept unexpired I-9 List B documents. U.S. Citizenship and Immigration Services reminded employers that the Department of Homeland Security ended the temporary flexibility related to accepting expired List B documents for Form I-9 employment eligibility verification purposes. DHS explained that it adopted the temporary policy in response to the difficulties many individuals experienced with renewing documents during the COVID-19 pandemic. The document issuing authorities have reopened and/or provided alternatives to in-person renewals. If a current employee presented an expired List B document between May 1, 2020 and April 30, 2022, employers must update their I-9 forms by July 31, 2022.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!